if one parent is giving conditional support, that I will only give parental responsibility if this child lives with me, then this person has to give enough proof to show why is he best or why is she best placed to live with this child and not the other parent. And one of the ways that you can do this is giving, bring evidence. Probably this other parent has mental health issues. Probably this other parent has drug issues. So the court looks at certain circumstances before it makes this decision. My name is Caroline Janja. I'm an advocate of the High Court of Kenya with more than 5 years of experience post-admission. I currently work as a legal consultant at Crime Sipoa. And today, on our Ask a Lawyer questions, we will be handling children and the law on various topics such as child custody, maintenance, neglect, child trafficking, and child labor. Our first question of the day is, my ex-husband and I divorced 2 years ago. After I endured too much domestic violence, I left him with our 5-year-old son because I could not provide for him at the time and needed to look for a job. My ex-husband took our son to live with his mother and got a new wife. Now that I am stable, I want to take my son back. My ex-husband has refused to give me access to our son. Does the law allow me to take custody of our son? Yes, the law does allow you to take custody of your son because there are two types of custody. There's the legal custody and the actual custody. Actual custody is actually basically it means the actual possession of you having this child, and the court can grant you custody if you are able to prove to the court why you are the best person to be in actual custody of this child. Despite you being away from your son for 2 years, and you're able to show that it was not willful neglect or willful desertion of this son, then the court can look and balance the interest of the child vis-a-vis the balance of balance the interest of the child and the parents. It will look at who is in the best interest to take care of this child. Is it the mother or the father? Even if the father has the actual custody, you see, none of the parents, though alive, is taking care of the child because he's being taken care of by the grandmother. The court will look at other things like what about the continuation of his education? How will it affect you taking custody of this child? How will it affect this child? Are you in the mental and health space? Are you in a mental and health space to be able to take care of this child? What are the wishes of the relatives of this child who have been bringing up your son? The grandmother, the court will look at what are her wishes. Probably the grandma might not have a problem. She might be like, now that the mom is able to take care of the child, then they can release the child to you. So yes, you can when you exercise the legal means, and the court can always does award custody to the parent once there is sufficient cause to warrant such an order. Another similar question, the second question, I recently found out that I have a daughter who was hidden from me for 10 years by my ex-partner. After living together for 4 years, we separated while she was expectant, which I had no knowledge of. I want to get access to my child and play an active role in her life by providing for her and getting to know her. My ex-partner has since remarried and refuses to give me access to my own child. What legal action is available to me in this matter? In this situation, one, before running to the courts, you can go to the children's office, and the other parent can be summoned, and they will be requested to come and give their side of the story and to see whether you can be able to sit down in front of a children's officer to come up with an agreement on how you can bring up this child together, though separately. Looking at that, even there's a new dynamic to this, that there is another step. Your other partner is remarried to somebody else, so it also brings in an element of blended family. So what you can do is, once you are at the children's office, you can share both your views how you want to bring up this child. If the meeting is successful, then you can come up with a parental responsibility agreement which can also be drafted at an advocate's office. If that is not, if that does not yield any good results, then now you can file the matter in court for child custody and maintenance, because under our Article 53 and the Children's Act, parental responsibility is an equal responsibility, and you have an opportunity, and you also have an equal opportunity to take care of your child and, you know, be actively, not just provide financial support but be active. The court will also look at so many other things. The child, what are the wishes of this child? Is it in their best interest for you to just come in? What are the things that should be done before these orders can be made, the custody and maintenance order? So there are so many avenues that you can get access to, that you can use to get access to your child. The third question, my late sister left behind her infant child, whom I have raised as my own son for the past 6 years. Last month, my late sister's husband came back and wishes to take away the child to raise him as his own. I do not wish to give my nephew up, as I feel that he is too young, and such a move will destabilize him. Besides, he is now like a son to me. Does the law require me to relinquish custody of my nephew to his biological father, who has been absent these past 6 years? At the end of the day, this child belongs to this man, so the court will not outrightly deny access, the father access to him, but the court will take into many consideration what is the age of this child, where has the father been for the past 6 years, what efforts has he made to be in the child's life, is it out of circumstance or just willful neglect? Because you see, when you just disappear from a child's life for 6 years, then that is child neglect. You know, you have not been able to provide this child with their basic needs. Probably they've even been having challenges accessing some of the things that they need, let's say school. They have been, you know, they have been exposed to other difficult conditions, yet you are there and you are able. So the court, before it orders you to relinquish your custody, there's so much that the court takes into consideration. For instance, what we can see, this is a child who is 6 years. This is a child who can express themselves. They'll also take into consideration of what this child wishes, that do I want to go now to my dad who has now turned up all of a sudden, or do I still want to be with my aunt? The new Children's Act has also introduced a new element, a new type of adoption, the kinship adoption, which gives relatives an opportunity to adopt children within their family who are, without going through the other lengthy process of adoption. So this is also an opportunity where you can seek for kinship adoption of this child. But most of the time in such a situation, the court might not give immediate custody to this child, to this father. First, what they might require is give visitation rights to this father. You can come in and be seeing this child maybe twice in a week, once in every weekend, or just to see and assess, is the child able to bond with the father? Is the father able to take care of the needs of this child and bring up the child in a proper way, so that you do not destabilize the child so much. Today he's under his auntie's care, tomorrow he's under his father, it's not working, then, you know, that push and pull of the child is not also very good for their development. So the court looks at many other things that before it can order custody, before it can relinquish your custody over the child. The other question is, can a child be allowed to decide on who to stay with in case of a divorce, and if both parents are financially stable? Before the court takes into consideration of a child's interest, the court will look at one, the age of this child. Is this a child who has an understanding of what is the matter that they're being involved in? And two, do they have an understanding, a good understanding of the issues that are in court touching on their custody and their maintenance. Then the court, before it places, it relies on the wishes of the child. Sometimes the child will be taken to be assessed by a children's officer, and the officer will be able to get more information on the upbringing of this child, their relationship with either parent, why do they want to really go with this parent, is it in their best interest, what has informed them of making such a decision. So the court is careful to rely on the wishes of a child, because sometimes you find that children, they may be misled, they may be misadvised, they may not really understand the implication of saying that they want to go with this other child. So yes, the court takes into consideration, but it does not just rely on that to make its decision on child custody. The last question is, how about a situation where a parent says he or she will only assist the child if they are staying with him or her? As I've said before, parental responsibility is an equal responsibility. So if one parent is giving conditional support, that I will only give parental, I will only do my share of parental responsibility if this child lives with me, then the court will, then this person has to give enough proof to show why is he best, or why is she best placed to live with this child and not the other parent. And one of the ways that you can do this is giving, bring evidence. Probably this other parent has mental health issues. Probably this other parent has drug issues, substance abuse issues. Probably this parent is not able to provide good living conditions, or probably they are not financially stable. There is a lot of instability with the other parent. Probably the parent keeps moving, the parent has no formal job. So the court looks at certain circumstances before it makes this decision. Just because this parent is demanding that they live with the child, that the court will not be quick to give this parent actual custody, but it will look, is it in the best interest of the child? So you can always go to court, you argue out your case, and once you're able to argue out your case, then the court can actually give you actual custody, even if the other parent is only conditional. And one of the good things of going to the children's court is that sometimes where there is a power imbalance, because one parent is financially unstable in comparison to the other parent, then the court, once it gives an order, it also, there are other avenues of ensuring that this enforcement order has been that the court order has actually been enforced. So if this parent is not willing to support you, then you can always take them to court, and then you get a maintenance order that you can actually enforce in court without relinquishing your custody of this child. So thank you. I think that brings us to the end of our questions for today. Thank you very much for your questions. And that brings us to the end of our questions for today's Ask a Lawyer segment. Thank you so much for your questions and also listening to me. For further information and clarification, or even more questions, you can get to us through our Facebook page, where we drop a link every Tuesday and Thursday, where we have a virtual legal awareness session on various topics. So join us and help us to be able to give you more legal knowledge and solutions to your problems. Until we meet again, bye.